Hello, everyone. Welcome to the webinar today. We are so thrilled to have you with us. We have an excellent topic today talking about California's balcony inspection law and the relevant deadlines that are coming up. So we definitely want to make sure you all are prepared for that. So we brought on two experts with us to speak about this new law, actually the two new laws related to balcony inspections. We have with us Gregory Carlos. Greg is the VP of Sales and Operations at Dr. Balcony. And we have with us as well Edrin Shamtob, the managing attorney and founding partner at SNS Law Group, LLC. So both of them are going to go through some of those top points. But first, I want to start with a couple of poll questions because we want to get to know you a little better. So the first poll question here is to select what best describes you. So go ahead and pick one of those options that you see there on the screen so we can better tailor this presentation to you. And then I'll give you just a moment to set that up here and tell us, are you a property owner, property manager, HOA board member, realtor, or a tenant? If you're a tenant, that's interesting. You definitely want to know a little bit more about what's going on in the rental housing world. So very cool. Okay, I'll go ahead and end the poll here in just a moment. So it actually looks like most of you are property managers. And then in second place, we have the property owners. We do have some HOAs. So we'll be covering how those different aspects may affect you all differently. And then also the other question we wanted to ask you as well is how many properties do you currently own or manage? This also matters a little bit here when we're talking about anything legal related. So let us know here if it's 1 to 2, 3 to 10, 10 to 50, 50 or more, or you don't own or manage any properties. Maybe you're just about to, or you're one of those tenants that was joining in. And in the meantime, I would love to pass the presentation along to our speakers here. So if you all could share your slides, we can get started with that in just a second. Okay, great. So I'm going to end the poll here and share the results. And Greg or Edrin, if you can share your screen.
Yeah, I'll go ahead and I'll share my screen.
Wonderful. All right, so you all can see most of you have 1 to 2, and then in second, 50 or more. So this is actually a pretty varied audience that we have today. Interesting. I think we'll be able to cover a little something for everyone. And of course, as usual, this whole thing is being recorded. We are going to have Q&A at the end. So put your questions in the question box and not the chat so that we can keep track of that a little better. Again, questions in the question box, not the chat. We will be prioritizing questions in the question box first. So with that said, Edrin and Greg, thank you so much for coming on and speaking to our group again. Very excited for this.
Thank you so much, Alexandra. Always a pleasure to be with you guys. I always love appearing, helping, viewers and members come up to speed on new laws that impact their rental properties and that'll assist them to stay in compliance with the new legal frameworks that have been passed by the California legislature and also local municipal districts. To make sure that the property owners, property managers can put their properties to productive use. My name is Edrin Shamtob. I'm a practicing California real estate attorney. I've been practicing law for 11 years, and my office focuses heavily on real estate litigation. A big part of that is landlord-tenant law. We help, like I said earlier, landlords, property owners, property management companies stay in compliance with new laws coming down the horizon. And we also assist landlords and property managers evict tenants who are breaking the rules, not paying their rent, engaging in nuisance activity, those types of things. So the subject matter today is going to be new laws and legal issues, specifically pertaining to AB 1482, which is a statewide rent control law that was passed in 2019. So it's about 5 or 6 years old, but there's been multiple laws that have come down the pipeline that have amended AB 1482, made it a little bit more restrictive. So I'm going to talk about those amendments and how it impacts the properties, the multifamily properties particularly. There's new positive credit reporting requirements where landlords have to give their tenants an option to have positive rent payments reported to credit bureaus to assist tenants to build up their credit history. Third, I'm going to be discussing new security deposit laws that were passed recently that are going to impact the landlord's ability to make deductions from security deposits once tenants exit and vacate properties. And I'll have a quick snippet before I pass it off to Greg on California balcony inspection laws. Let's dive in and talk about AB 1482. It has a fancy title, the Tenant Protection Act. It was passed, as I stated, in 2019. It went into effect in July 2020. And the crux of the law is this. Before AB 1482 was passed, rent control was mainly governed by local municipalities. So you talk about Santa Clara, San Francisco, here in Southern California, where my office is, Los Angeles, Santa Monica. Every single city had their own specific rent control law. Well, in 2019, the state of California came out and has said, for those cities which have not enacted local rent control, the state was going to implement a statewide rent control measure that applies generally to multifamily properties. And as I mentioned earlier, I'm going to jump into Senate Bill 567, which modified portions of the Tenant Protection Act. So, what is the Tenant Protection Act? In the good old days where you had a multifamily property, and I say the good old days because those are the glory days for landlords where they could basically do what they wanted with their tenants. If you had a tenant who was originally on, let's say, a 1 year lease, and that lease expired, the tenant would roll over into a month-to-month tenancy. If the tenant was in a month-to-month tenancy, all the landlord would have to do to recapture their property, regain possession, is issue either a 30 or a 60-day notice to quit, and the tenant would just have to leave. After AB 1482 was enacted, that is no longer the case. Even if a lease or a tenancy rolls over into a month-to-month, what AB 1482 now requires is specific reasons why you're allowed to terminate your tenant's tenancy. The law calls this just cause. So the law enumerates certain specific reasons and only those reasons where you're able to kick the tenant out and recapture your property. The law also imposes a rent cap. So before the onset of the Tenant Protection Act, landlords could adjust once the tenant was on a month-to-month tenancy. They could increase the rent to whatever they wanted. 100% increase, a 50% increase, a 10% increase, whatever the landlord decided to do. With the passage of the Protection Act, now the landlord is capped to around 10% annual increase in rent. I want to go back to the just cause requirements that I was talking about earlier. The Tenant Protection Act, again, limits the eviction basis for a tenant. And it categorizes those reasons into two different categories. One is an at-fault just cause reason, and the other is a no-fault just cause reason. The at-fault is essentially where the tenant has done something wrong. For instance, they have failed to pay rent. That is an at-fault just cause reason for an eviction. They have brought in unauthorized occupants. They've brought in a pet where the lease agreement says no pets. They've engaged in nuisance activity. They've caused damage to the property. They've made modifications to the property without landlord approval. Essentially, anything that the tenant has done wrong that violates the lease agreement constitutes an at-fault just cause eviction basis. On the flip side of that, there's certain scenarios where the tenant has acted perfectly fine. They haven't violated the lease agreement. They paid rent on time. The Tenant Protection Act still allows the landlord in some limited circumstances, even in those scenarios where the tenant hasn't done anything wrong, for the landlord to recapture their property. Those are entitled as no-fault just cause reasons. For instance, if you as an owner or one of your immediate family members wants to move into the property and you want to get the tenant out of there so you can have your daughter or your son or your parents to move in or yourself to move in, the Tenant Protection Act allows the landlord to conduct what's called an owner move-in eviction. If you want to substantially renovate your property, if you have a dilapidated property, or if you want to, adjust the electrical panels, or add recessed lighting, or fix plumbing issues, and those types of things, the Tenant Protection Act allows a landlord to recapture their property under a substantial renovation. And then finally, an Ellis Act removal. The state of California allows landlords to exit the rental property if they wish to. In other words, they've elected not to rent out their property any longer. If you decide that you don't want to rent to anyone anymore, the Tenant Protection Act allows you to recover possession of the property under an Ellis Act. So that's the general gist of the Tenant Protection Act. I should mention a couple things. It generally applies to multifamily properties. Okay, multifamily properties, single family properties, and condominiums are generally exempt from the Tenant Protection Act so long as the landlord owns the property in their own name or through an LLC, and provides the tenant with an exemption notice, basically informing the tenant that the property is exempt from the Tenant Protection Act. So what I'm going to discuss is generally multifamily properties in the context of Tenant Protection Act. Now, Senate Bill 567, what did that do? This was passed about a year ago. And essentially, what it does is strengthens tenant protections. Specifically, as to those no fault eviction basis that I discussed a minute ago, the owner move in, the substantial renovation, and an Ellis Act removal. When the Tenant Protection Act was originally enacted back in 2019, there weren't many protections set in the law to protect tenants. For instance, under an owner move-in, my a client would come to me and say, "Hey, I want to move into the property." I would prepare the notice. I'd issue the notice to the tenant. The tenant would vacate, and the landlord would not even have to move into the property at all. They could turn around and just rent it out to somebody else. Under a substantial renovation in the older version of the law, the landlord could just issue a notice saying, "Hey, I want to put in recessed lightings, I want to fix the plumbing, I want to do structural work." The tenant would vacate, the landlord would not end up doing the work, and there was no penalty. Well, the California legislature caught on to that, and through Senate Bill 567, they've made those options more restrictive. For instance, in the context of an owner move-in, the law now requires the landlord to actually move into the property. I should say landlord or immediate family members to actually move into the property within 90 days of the tenant vacating the property. The law also imposes penalties if that doesn't happen. For instance, if you don't move into the property within 90 days, the tenant is allowed to come back. You actually have to go to the tenant and re-offer them an opportunity to return to the property at the same rental rate they were paying at the time they vacated. The landlord must now occupy the property for a minimum of 12 months. If you move in and you leave within 6 months, you got to go back to the tenant and give them an opportunity to come back. The same thing goes for a substantial renovation. As I mentioned before, you would notify the tenant that you want to substantially renovate the property, and you just wouldn't go through with the work. Senate Bill 567 now requires you to do a couple things. Number one, you have to acquire the permits reflecting the work that you're going to perform before the tenant vacates. You actually have to get the permits, attach the permits to the notice to quit, and give a copy of both the notice and the permits to the tenants. If you don't do that, you cannot evict your tenant under a substantial renovation. Secondly, you must actually go through with the work. You have to get the permits, give the notice. After the tenant vacates, you must commence the work and complete the work. If you don't complete the work, you have to go back to the tenant and give them an option to return. And then finally, withdrawal of the property from the rental market. This is the Ellis Act provision. The prior version of the law did not specifically spell out what a landlord had to do in order to remove the property from the rental market under the Tenant Protection Act. Senate Bill 567 specifies that under the Tenant Protection Act, the landlord has to give certain notices and a certain amount of time to the tenant before the property can be removed. And it also specifically designates a certain period of time that the property has to be removed from the rental market. In other words, you cannot just remove the property from the rental market, wait a month, and then put the property back onto the rental market. Generally, under an Ellis Act removal pursuant to Senate Bill 567, you have to keep the property off the rental market, which means you cannot rent it to any tenant whatsoever for a minimum of 5 years. Okay, which is a pretty significant penalty when you think of it, because you can't earn any rental income for a long period of time, at least 60 months. So Senate Bill 567 essentially strengthens tenant protections when it comes to no fault evictions under the Tenant Protection Act. Positive credit reporting. I've got a lot of calls, a lot of clients who can't figure out the specific requirements of positive credit reporting. Earlier this year in January, the California legislator passed AB 2747. And they passed it as a measure to assist tenants to help them build up their credits. Essentially, what AB 2747 requires is landlords, and very specific, and I'll talk about who it applies to, which landlord it applies to in just a second. But it requires landlords to essentially provide notice to their tenants of their right to have positive rent payments, actual rent payments, reported to credit bureaus like TransUnion and Equifax. The notice requirement was supposed to be sent out by landlords by April 1st of this year for existing tenancies. So if you have existing tenants and you did not provide them notice of their right to have their positive rent payments reported to the credit agencies by April 1st, you should do so immediately, because technically you're in violation of the law. The law also requires landlords for any new tenancy to provide that notice as an addendum in the lease agreement. So if you're not putting the positive the credit reporting notice in your lease agreements as an addendum, you have to start doing it starting July 1st, which is just in a couple days. Now, who does it apply to? It generally exempts mom and pop landlords. Okay, it applies to property owners who have buildings with more than 15 units. So if you have one building with 16 units or more, you have to comply with the law and you have to provide the notice to your tenants. It also applies to landlords who own their properties through a corporation and which own two or more buildings generally. So if you have two buildings, no matter how many units there are, and you own those buildings as a corporation specifically, the law applies to you and you have to provide the notice to your tenant. Lastly, in terms of how much cost you can pass on to your tenants, the law caps it at $10. So you can essentially charge your tenant $10 to report their positive credit reporting to the credit agencies. So if you're not in compliance and the law applies to you, contact our office. We have notices ready to go. We can give you a free copy of it so you can get it out to your tenants, and we can also help guide you on the addendum that has to be included in your lease agreements moving forward. That's positive credit reporting. Let's quickly talk about new security deposit laws. I don't know what it is with security deposit laws, but they've been on the attack against landlords in the last couple of years. There was a modification made last year that basically capped, previously, a landlord could have charged 2 months worth of rent for security deposits for an unfurnished unit. Last year, they passed a law that now caps it at 1 month. So you can no longer accept 2 months unless you're a mom and pop landlord, which I'll discuss in just a minute. This is a new security deposit law that came into effect, AB 2801. This is in addition to the limitation that went into effect last year that capped it at 1 year. So now landlords are required to do a couple things. First, landlords, for any new tenancy that starts, landlords have to take pre-move-in photographs of the condition of the property. Okay, so you got to go in there before the tenant moves in and you have to snap photographs. When the tenant thereafter vacates, okay, post move out, you have to also take photographs. And then those two sets of photographs have to be supplied to the tenants as part of their security deposit itemization. Basically, the law now requires for you to prove to the tenant the change in the condition of the unit from pre-move in to post-move out. If you fail to include those photographs in your security deposit itemization, when you're taking into account the security deposits or you're deducting from their security deposits, you are not allowed to make any deductions. Okay. And obviously, this only applies to new tenancies. If you have a prior tenancy, you never had an opportunity to take photographs beforehand. So if you have a tenant that's moving in now, make sure you're snapping photographs of the interior of the unit. And then once they vacate, make sure you're taking photographs of the condition of the property at the time they're vacating. And you have to supply them with those photographs as part of the security deposit itemization you provide to the tenant within 21 days of them vacating. And if you can't do that, you're not allowed to make any deductions, and you have to return the entirety of the tenant security deposit back to the tenant within 21 days. Um, Finally, California balcony inspection laws. Greg is going to talk extensively about that, but this is basically governed in SB 721. SB 721 requires properties of multifamily buildings to conduct regular inspections of balconies, decks, and stairways. And what I want to highlight for you is how frequently you must conduct these inspections. The law requires you to conduct the inspections every 6 years. Okay. And in terms of collecting records relating to those inspections, you have to maintain records of those inspections for 2 periods, which essentially equates to 12 years. So if you do an inspection today and you get a report from a balcony inspection company, you have to maintain those records for 12 years. And the purpose of the law is to ensure that landlords are maintaining their balconies. There's been many accidents, if you will, that have caused harm to people who come onto multifamily buildings or to tenants who step onto balconies while the balconies were effectively failing and causing serious injury. So the state of California came down and now requires landlords of multifamily buildings to conduct regular inspections every 6 years. If you fail to comply, there's going to be penalties imposed. So make sure you're in compliance and that you're aware of Senate Bill 721. And Greg Carlos from Dr. Balcony is going to do an extensive presentation on the new balcony inspection laws that have come into effect and how to comply with that. So I'll go ahead and I'll hand it over to Greg, and I'll stand by for questions and answers subsequently. Again, I'm with SNS Law Group, LLP. We focus generally on real estate litigation. We do a lot of landlord tenant compliance. Make sure you can put your property to productive use. Make sure you're not getting sued by your tenants, and make sure that you can make money off of your properties. That's what we help our landlord and property management clients do. And I'll go ahead and I'll stop sharing it, and I'll go ahead and I'll pass it off to Greg, who could talk about the balcony inspection laws.
Thank you so much for that, Adrian. That was
Sure.
amazing. Thank you.
Of course, Greg.
All right, guys, let me share my screen here really quickly. Let me see. All right. Can everyone see my screen? Adrian, are you able to see it?
Yes, I can.
All right,
Absolutely.
perfect. All right. Well, thank you all for having me here today. My name is Greg. I'm here on behalf of Dr. Balcony, the Balcony Inspection Services. We're going to be talking, like Adrian said, about the balcony inspection laws, obviously, and then we're actually going to be talking about another law as well that he briefly went over, the AB 2801. So with that being said, Alexandra, I believe we had a couple of poll questions we wanted to ask here. The first one was, have you already conducted your balcony inspections? I believe it cut off
Yes.
there. But yeah, have you already conducted your balcony inspections? Just wanted to see which part we should focus on, maybe the inspection process itself or the post inspections, right? What comes next?
Yeah, I did see someone comment that they had an inspection that they failed. So I think we're
Okay.
starting to see more of the, AAOA members and other landlords kind of start to get to that part in the process where, they're starting to see the results now of the reports. So let me go ahead and give you all just another moment here. Looks like almost half of you have answered the poll. So get in your response. Okay. Great. I think we have enough of you to get a good gauge here. So I'm going to go ahead and end the poll and show the results. So it looks like we have a good mix here. 39% yes, have already done it, 13% in progress, and 48% not yet.
Okay.
So making progress here.
Yeah. Yeah. And hopefully that that other 50 or 61% wraps it up. fairly soon, right? We don't wait
Mm-hmm.
until that deadline. Definitely. But I think we had another poll question, right, Alexandra?
Yeah. So do you have any exterior elevated elements such as balconies, decks, stairways, or walkways? On that note, I'll say, Greg, we did get a question about poolside decking from Lorenzo in the Q&A. Thought that was interesting if that might be considered an exterior elevated element. I'm sure you're going to go over what that exactly is. These are some examples here, but the poolside deck one is interesting. What do you think?
I've seen a lot of poolside decks that aren't meant to be walked on. So if they're
Mm.
not meant to be walked on, it's gonna be a no. And when, like you said, we're going to go over the uh exterior elevated elements and what qualifies as an exterior elevated element. Hopefully that'll help answer that question as well. If it doesn't, and you still say, hey, well, I just want to be sure. We'll also give out our contact information so you can maybe sh send us a picture, right? For these one-off scenarios, I like to see it before we tell you, hey, yes, or maybe no.
Yeah, right. Lorraine asked if it's elevated is 6 feet high. We're going to go over all that in just a moment. So, what exactly is elevated enough, how many feet, and all. So, let me go ahead and end the poll here and share the results. It looks like most of you do have exterior elevated elements. A few of you say no or that you don't know. So, we'll go over that in just a moment as well to see if those of you who said you don't know, you should know, hopefully, after we're done with the presentation. And if you still don't know, you should definitely contact Dr. Balcony and Greg. Again, just to also reiterate, we are going to be sending everyone the recording and the slides, both slide decks, both speaker contact information, so you have those resources later. So I'll go ahead and stop the share here and let you take the presentation away, Greg.
Perfect. Thank you so much. So before we get started here, everyone, I just wanted to have a quick disclaimer. Um, I'm not an attorney myself. This isn't legal advice. This is advice that we're trying to give to the best of our knowledge, having this experience in the industry. But by participating in this webinar, you acknowledge and agree that we're not responsible for any decisions you make or outcomes that may result from information shared, right? So once again, this is meant to help everyone, but I'm in no way an attorney. All right, everyone. So who is Dr. Balcony? A lot of you may have heard of about us, but we are the one-stop shop for balcony inspection needs. We've completed over 5,000 inspections to date. I believe that's the most in California by a margin. Additionally, we provided the best price out there. We have a best price guarantee always. We're really confident in our pricing. If for some reason you happen to find a price that's lower than ours, we're actually so confident that you won't that we'll beat that opposing bid by 20%. So if by any chance you find an opposing bid, please let us know. You get it. You're going to get a really good price. Uh, Apart from that, we're an engineering firm, so we do the inspection and the architectural portion of these inspections, but we will not do any sort of construction. So, you have no conflict of interest with us. We're just trying to, help as many people comply with these ordinances as possible. So why these inspection laws are and these balcony laws are important. So one, it's important that you understand the SB 721 and SB 326 requirements so that you can make sure that you stay fully compliant ahead of the 2025 deadline. You want to protect your legal risks and at the same time protect your tenants, yourself, right? If you're walking on that property. And overall, this is for safety, guys. So, really, really important laws here, and hopefully, we're going to help a lot of you comply today. And how big of a concern are these laws, right? I know this is probably the biggest kickback that we hear is, hey, well, this rarely happens. Well, actually, there's over 6,000 serious injuries annually relating to exterior elevated elements. So whether that's walkways, stairways, balconies, anything like that, there's over 6,000 annual injuries. There's a 21% increase in balcony and deck failures annually as well. 550 trauma center admissions annually, and tragically, about 140 children's deaths annually relating to exterior elevated elements as well. And according to a report by the California State Senate Committee on Housing, more than 90% of balcony failures over the last 20 years have involved wood deterioration that went undetected. So that's actually a big thing that we're looking for in these inspections, and that's why they're so important and they're mandatory at this point. We have a quick video prepared here for you all. This is, keep in mind, this is only incidents that have been captured on video, right? There's so many of these that were never captured on video that happen every day. That first one you saw there is going to be the Berkeley incident that actually started this law. It's the reason that this law was started, and we're going to get into that in a little bit. But as you see, there's a lot of really, really scary incidents that are happening really, really often in our surrounding areas. There was an incident similar to this one that we see here where someone's actually going through that balcony uh actually in Vista last week. Uh this one right here is going to be that Malibu incident that happened a few years back. And this last one is going to be the Los Angeles incident that actually happened only 3 months ago. It happened in the middle of February, I believe February 15th. So really, really scary stuff. It's in LA, right in our backyard. So um it is definitely a persistent problem that's happening all around us. So two specific ones that we're going to talk about today is going to be first off that 2015 Berkeley balcony collapse. So this is the entire reason that these two ordinances were created. The 10-year anniversary was actually about a week ago or so of this collapse. So 13 young adults that tragically fell 40 feet to the ground, where six were killed and the other seven were seriously injured. Uh, uh, the building was only 9 years old, so after further investigation, right, they found that dry rot was the reason that this balcony collapsed. And a lot of people would consider a 9-year-old building to be relatively new, and that was really shocking to everyone. So once they saw this, and they saw, hey, it's only a 9-year-old building. That's why they started these two new ordinances. And then the most recent one that we know of is going to be the 2025 Silver Lake balcony collapse. This was in February. Only four people were hanging out on this massive balcony, four people and a dog. And thankfully, there was a second floor balcony because this balcony was on the third floor that actually caught the fall right under, and therefore everyone was okay, right? There was one broken arm, but there were no tragedies in this incident. But if it wasn't for that second floor balcony that caught that third floor balcony, this would have ended a lot worse. You know, easily people would have lost their lives. So, these are happening in our neighborhood, and we have to be aware of that. So quick SB 721 versus SB 326 overview. So SB 721 applies to multifamily apartments with three or more units, and the deadline is the end of this year. The deadline was originally December 31st, 2024, but that deadline was extended 1 year. So for these inspections, you need to inspect a minimum of 15% of each exterior elevated element type. So if you have 100 balconies, 100 stairs, you're going to need to inspect 15 balconies and 15 stairs. Who can do these inspections? You can have a structural engineer, an architect, a general contractor, certified home inspector. They have to have specific licensing for these inspections, but there is a large variety of people that can do these inspections. And these inspections, once again, have to be done every 6 years, and therefore you should keep that report in your record for 12 years. Cities are able to retroactively ask for these inspection reports. The SB 326 on the other side applies to condominiums and HOAs, also with three or more units. The deadline was also originally last year. And though a lot of people may think that was also extended, it was actually never extended. So the deadline was still December 31st, 2024. That deadline has now passed, and there's still a lot of HOAs that have not complied. A lot of you may live at an HOA that maybe did not comply with these inspections, and now you're seeing the consequences, and maybe that's why you're here, right? But that deadline, once again, did not get extended. It was December 31st, 2024. And for the condominiums, you actually have to inspect 95. Um, the law reads 95% confidence rate. So all exterior elevated elements are going to be inspected for these as opposed to the 15% for the SB 721. These inspections are every 9 years as opposed to every 6 years because they're a lot more thorough, being that 100% sample size. And the only people that can do these inspections are structural engineers or architects. Once again, you should keep these inspections in your records for 2 cycles, which is going to be 18 years. What are exterior elevated elements? A lot of people know these laws as the balcony inspection laws, but they do not just apply to balconies. Uh, they apply to anything that's 6 feet above the ground, has a walking surface, meant to be walked on, and is relies partially or wholly on wood for its structural support or stability. And additionally, it has to be on the exterior, right, exposed to natural elements. So balconies, walkways, decks, porches, like I said, anything on the exterior that's above 6 feet off the ground. So we have some examples here. You're going to see on the left side in that green circle, cantilevered balconies. So these balconies are extending beyond the envelope of the building, and therefore everyone's in agreement. Hey, these need to be inspected, right? In the middle there, you're going to see some Juliet balconies. As you can see, these balconies don't have a walking surface. They're not meant to be walked on, and they're purely for decorative purposes. So therefore, they're going to be exempt. They don't require any sort of inspection, and you can forget about those when it comes to these ordinances. On the right side, these are probably the balconies that are causing the most confusion in the community right now. Just because I know they're not cantilevered, they're not sticking out from the building, and therefore a lot of people believe they don't need inspections, but they still meet all requirements of an exterior elevated element. They're 6 feet above the ground, have a walking surface meant to be walked on, rely on wood. Therefore, these also have to be inspected, right? These are also exterior elevated elements. So if you have these types of balconies, make sure you're also getting those inspections so that you can be in compliance as well. So a couple more examples of exterior elevated elements. I really like this example here because you get to see the three makes of walkways. So on the left-hand side, you're going to have an exposed exterior elevated element. As you can see it's completely wooden. You can see the joist. You can see everything from the bottom. This is going to require purely a visual inspection. This does need to get inspected as well, but there's not going to be any sort of drilling or anything like that. This is considered an exposed exterior elevated element. In the middle, that second photo is going to show enclosed exterior elevated elements. So though you may not see any wood from the naked eye, once you actually drill inside of that stucco that's underneath that walkway, you're going to be able to see the wood that's inside, right? So that's also subject to inspection, even though there's no exposed wood. You know, the exterior elevated element still relies on that wood for structural stability and support, and therefore it requires an inspection. Then on the right-hand side, you're going to have a walkway and stairway that's completely metal and concrete. Because it's completely metal and concrete, this is actually not subject to an inspection. So if there's no wood at all on the exterior elevated element, you're going to be completely exempt from an inspection. And some warning signs that you can check for just to see if maybe you're going to fail this inspection, or maybe you should jump on this inspection as soon as you can, or maybe it's posing a danger for yourself or your tenants, right? So any cracks, any rotten rust, any unstable railings, signs of water intrusion in the stucco, right? Any of these items that can indicate that there's a moisture intrusion, and moisture intrusion is obviously going to accumulate and build up and eventually create rotting, and that's what's going to cause the unsafe balconies or unsafe exterior elevated elements. So any of these signs, please look out for, and if you see any of these, you should definitely hop in an inspection as soon as you can. So the balcony inspection process. I really like this example here because it shows why you need more than just a visual inspection. So a lot of people say, hey, well, I just want a visual inspection. I don't want any sort of intrusive testing. So, Dr. Balcony, we'll get into this a little bit more later, but Dr. Balcony has a patented inspection method where we're going to drill small holes under the balcony. We're going to insert a borescope camera and take detailed images of what's going on inside of that exterior elevated element. And these holes are about the size of a nickel. They're really small, but they're really going to be beneficial for these inspections. So the property on the left, it really stands out to me because it had about 20 balconies or so that looked exactly like this. No warning signs from the exterior. Everything looked amazing. Uh, there was no staining. There was nothing. Therefore, from a visual inspection, it would have passed. However, with Dr. Balcony's inspection method, where we're actually going to drill into that balcony, creating those small holes, we saw a lot of rot. After that, we ended up, recommended that this, be repaired and that they take action on these balconies. And once they opened it up, they saw that this was completely rotted, right? As you can see in that second photo, right? That's really dangerous. That's definitely not what you want to see inside of your balcony. And thankfully, we were able to catch that. Now, not every balcony is like this, but once again, you should always have that intrusive testing just to have that peace of mind. And then on, with that inspection, and then we help them achieve their permits, right? We help with that permit process. We were able to save a lot of that original structure, and therefore they saved a lot of time, a lot of money, and now it looks like it does on that third photo, right? Which is going to be there was some joist string there, but obviously there's a lot of wood replacement as well, and now it's going to be all good to go, hopefully for the next 20, 30 years. So the typical inspection process, first you're going to call up Dr. Balcony or any other company. They're going to give you a proposal. This is typically free of charge, right? They're going to identify all exterior elevated elements on the property. And if it's an open exterior elevated element, if it's not covered like we saw in that first photo 2 slides ago, it's going to be purely a visual inspection. There may be a moisture meter test, but it's going to be really quick, really easy. If the exterior elevated element is covered, if there is stucco underneath, we're going to need to drill small holes about the size of a nickel, insert that borescope camera, take those detailed images, and then those images are actually going to be presented to you during your report as well. So that way you can see what we see. If we see any sort of rot or any sort of extreme corrosion, we're going to show you photos of that during your report. Once this inspection is done, we're going to write a report and give that report to the client. So what does the inspection report have to include? So we've seen all types of inspection reports here at Dr. Balcony. Please make sure that whoever you choose for these inspections, they have compliant reports, right? So the two most important things are going to be that there has to be photos on this report, right? So a company cannot just tell you, hey, I found rot, you're going to need repairs. No, they have to show you that rot as well. It must also be stamped or signed by whoever's doing this inspection, right? And make sure that their licensing is valid. So that way you make sure that you have a valid inspection report. In our case, a licensed architect or a professional engineer will be stamping and signing your report. Additionally, there should be identification of all exterior elevated elements. There should be a clear statement on the current physical condition of the exterior elevated elements, notes on expected future performance, and maintenance recommendations as well for your exterior elevated elements. Now, if you pass these inspections, you're all good. You're going to be in compliance. You should keep these inspection reports for your records for the next 2 cycles. Uh, yeah, the city's going to eventually ask for them, and you just have to show them those reports. You're going to be good for 6 years for apartments, 9 years for condos. If you have a non-emergency failure, which is the most common type of failure, the inspector is going to have to provide you with your report within 45 days of the inspection completion. After that, the you should apply for any necessary permits within 120 days. The cities are really getting backed up right now when it comes to permit approval, so make sure you hop on this as soon as possible, just because everyone's applying for their permits to repair their exterior elevated elements at this time. After that, once you receive the actual permits, uh, you're going to have an additional 120 days to complete any necessary repairs. Now, sometimes the city may provide you with a bit of an extension, about 60 more days, for a 180-day total to conduct any necessary repairs, but you have to make sure that they eventually get done, right? This is nearly a year of a timeline, right? You have 120 days, which is 4 months to apply for permits. It's going to be a couple of months to receive those permits, and then you're going to have 4 to 6 months to do the actual repairs. So you're looking at about a year from the day that you do your actual inspection. For emergency failures, you're going to have the inspector is going to have to provide you with the report within 15 days. Immediate preventative measures should be taken, whether that's temporary shoring, preventing access, whatever is recommended on that report. Additionally, you should apply for any necessary permits immediately. And then after that, once those permits are approved, you should conduct those repairs as soon as you can as well. So once again, just make sure you do the entire three-step process. You want to skip any steps. A lot of people are trying to do this without the actual permits. That's going to lead to a lot more legal consequences down the road. So the permit application process, once again, you may have small failures or small maintenance recommendations that aren't going to need these permit applications, and that's completely fine. We always recommend check with your city before doing any repairs, however. So if you do need repairs and there is something that's structurally wrong with the exterior elevated element, typically the city is going to ask for a licensed architect or engineer to create these plans that are going to show how you're going to conduct the repairs on these balconies or exterior elevated elements. After that, the way that we do it is that we will create those plans for you. We will submit them to the city for you. And then we keep going back and forth with the city until these permits are approved. So once these permits are approved and the the permit is in an RTI stage, which is ready to issue, then at that point, you're going to hire a licensed contractor who is going to pull that permit from the city. They're just going to follow the steps on that permit and on those plans and make sure that they repair the exterior elevated elements appropriately. So once again, guys, make sure that you comply with the three-step process, the inspection, the permits, and then the construction. Skipping any of the steps could result in a variety of consequences. The one that I've been hearing of the most is insurance companies dropping you from their insurance, and additionally, difficulty with financing and refinancing. So, a lot of people that didn't have their inspections done for the condos, for example, for HOAs, they're actually not able to sell their property at this time, and they've been blacklisted from refinancing or people from acquiring loans in order to purchase their condo. So it's causing a lot of consequences at this time. Additionally, if you try to do any sort of repairs without doing the actual permits. The city's going to make you get those permits. They're not going to accept those repairs. You're going to have to tear everything down and start all over. So there's a variety of consequences. Like I said, the one that the law actually states is that cities can fine you $100 to $500 per day. I haven't seen anything that severe as of yet with the $500 per day, but I have definitely seen the $100 a day. So you don't want to be at risk of any of these consequences. Make sure you're complying with the entire process. And just some additional reasons, like we mentioned, you're going to have about a year from when you do your inspection typically to do your actual repairs. So might as well get that inspection done just for budgeting purposes. I know this is a scary project for a lot of people, especially if you believe that your inspection may fail, but at least you're going to know what you're going to need to repair, right? Additionally, this is for safety, right? This is the reason that these laws started in the first place. You want to keep your tenants safe, you want to keep your family safe. And a lawsuit from someone being injured is going to result in a much higher cost in these inspections and repairs. So, really quickly, guys, we're going to be talking about the AB 2801, which is going to be the security deposit law that Adrian mentioned earlier. So, the law actually began in April 1st, 2025, and there's a second portion of that law that's going to take place in 2020. In July 2025 as well. So we've actually launched the new app, Deposit Proof. Feel free to go check it out. We asked our friends in the industry, hey, what else do you need help complying with? This is something that they were really curious about and they were asking for help with. So we developed an app really easy to use. You're going to upload the photos onto the app and you're able to see your unit's history. You're able to make sure that you're in compliance with this law. You're able to make sure that your tenant receive those photos and acknowledge those photos. You have the option to allow the tenants to upload photos for this law as well, if necessary. And yeah, it's specifically designed for the AB 2801. And yeah, feel free to check it out, give us some feedback, and hopefully we can help you comply with that laws again. And for the last slide, once again, why choose Dr. Balcony? We're inspection industry disruptors. We're doing things a little differently. We have a three-step quality control process where we're going to have our field operator looking at your report. We're going to have our engineering team looking at your report, and either our senior architect or a professional engineer looking at your report as well. We've actually completed over 5,000 inspections at this point. We service all of California, from San Diego all the way up to Reading. We have the fastest scheduling time. We can schedule you anytime from 2 weeks from now until the end of the year if you're choosing to wait until the end of the year. And quickest report turnaround time as well. It's about three days to a week right now for report turnaround. Beyond that, we're also using AI to make sure that our reports are as accurate and perfect as possible. And once again, you don't have a conflict of interest with us, right? We don't do any sort of repairs. We're not going to find anything in there just to win a construction project. We're simply engineers and architects, and we just care about your safety and helping you comply with these ordinances. And at the same time, you have the best price guarantee with us. So yeah, if you would like to be contacted by Dr. Balcony, feel free to click yes. We'll send you an email, right? And just see if we can help you out.
Wonderful. Thank you so much for all of that information. So we have plenty of questions. Again, please put your questions in the Q&A box, not the chat. We are going to prioritize the Q&A box only for this presentation. We will stay, if you can, Greg, a little longer over the hour mark. And Edrin, if he's still around, maybe he can answer some questions as well. But I'm going to start with some of the balcony questions since there were plenty of those that were input here. Some of them you may have already answered, but I'll go ahead and ask it again. And also, as always, we will be sending you the full recording, the slides, and all the speakers' contact information tomorrow via email. Okay, so what happens if the board is aware of the repairs and dry rot and just putting the repairs off as they are not red flagged as urgent repairs, but they do know that dry rot is present? So sounds like an HOA board is what they're referring to.
Yeah, so something funny about the SB 326 is that if it's not emergency repairs, right? It doesn't they're not being as pushy as with emergency repairs, right? At the end of the day, the only people that can penalize you for this or that are going to be enforcing this is going to be your local jurisdiction. My recommendation is always go ask them, right? You don't want to be hit with fines out of nowhere later. But the next step would actually not be the repairs, it would be the permits, right? So my suggestion would be just get started on those permits, right? Those aren't going to be as costly as the repairs. So maybe you can start the process at the same time, show the city, hey, look, I'm working on this. We're going through the three-step method. And you're able to wait a little bit until you do those repairs in order to budget a bit.
Great, great. Thanks for explaining that. And asking if we pass or don't need permits, how does the state know we complied to the deadline of having the report being complete?
Yeah, so your report's typically going to have a date on there, and that's why you have to keep it for 2 cycles. Because that's why they ask that you keep it for 2 cycles, right? They're going to eventually ask for it down the line. Right now, cities are more worried about the people that are failing, and do need permits or repairs more than anyone that's passing. So they're going to ask for it eventually. Just keep it in your records and maybe in a year or so they'll start asking for those.
Great. Darla also asking if you have a list of preferred contractors for repair quotes.
Yes, we do. Yes, we do. Feel free to reach out to us.
Great.
They're people that have been recommended through our clients, and we can definitely help out with that.
Okay. Katie asking, does SB 721 apply to new construction, particularly a 200 plus unit multifamily?
It depends on when your certificate of occupancy was given. You're still going to need that inspection, but if it was built after, I believe it's 2021, it's going to be 6 years from when that certificate of occupancy was given for apartments.
Great. And just to answer Oscar's question here and a couple others, we're going to send the speaker's contact information tomorrow by email. Also, let's go back since we have Edren here now into some of the California housing laws. So David was asking for the security deposit. If the deposit is set for 1 month maximum, can we increase the deposit if they have a pet?
Yes, you can charge a separate pet deposit. Okay, so the 1 month does not include a deposit that you would take for a pet deposit. So that's a separate payment that you could require the tenant to pay.
Great. So again, with the security deposit law from Nona, with which lease date did the photo requirements start? I have two new tenants who moved in on June 1st and a second tenant who moved in February.
Okay, so the February one is exempt. The one in June is going to be applicable to.
Got it. Arlene was asking again for the security deposit charges. What if we did not have move-in photos since some properties were taken over? How are we to determine the move-out charges? Are we able to?
Well, this the question assumes that they have. I assume that they've owned the property at least for a little bit of time. The law, in terms of the effective date, it's going to go into effect, or it did go into effect, in June. So as long as these are all for new tenancies, it's not going to be applicable to prior existing tenancies because obviously you didn't have an opportunity to take the pictures for those tenancies. So any new tenant that comes in. I assume that the person who's asking the question has acquired the property now and can begin
Yes.
taking the photographs moving forward.
Lee asking here if there's a limit on a pet deposit.
There is no particular limit. Well, this is the problem with the question. Local municipalities have their own limit, so it depends on where the property is located and whether there's a local rent stabilization ordinance. For instance, the city of Los Angeles is going to have a different number than what you would see in San Francisco or Santa Monica. So it's a local jurisdictional question.
Great. Yeah, Jasmine was also asking if you can charge a monthly pet fee, which would be not a security deposit, but something non-refundable.
No, you cannot charge a monthly pet fee for the pet to occupy. You could do a deposit for any damage that the pet would cause.
Okay. Let's see here if I can pull up. There's a couple questions about the credit reporting. So one was asking if you can do negative, so missed rental payments.
The answer is no. You cannot report that to the credit agencies. Now, if you did file a lawsuit either an eviction case or a breach of contract case, and you got a judgment, that judgment can be reported and it'll harm the tenant's credit. But in terms of, the tenant missing 1 month's payment, the law does not allow you to report negative payments or missed payments.
Great. Again, if you want your questions answered, please put them in the Q&A box and not the chat. Let's see here. Lynn asking, can you increase the rent as a result of having a pet?
So if the so if the tenant moves in without a pet and then subsequently gets one, yes and no. For general local RSO properties, like for the city of Los Angeles on an RSO building, you're not allowed to do it. But if you had a single family property or a condominium that's exempt or a multifamily property that's built after the RSO cutoff date, you have more options. And in that event, yes, you would be able to charge more for the pet.
Great. And Janine asking about single family rental homes. So if you own, let's say, two single family rental homes, do you have to, and maybe a four unit as well, do you have to report those credit payments to the credit bureaus? Would
If
they?
you own the properties as a corporation and you own more than one building, yes. Yes, the answer is yes. You do have to provide them the notice and give them the option for you to report the positive rents.
Yeah, safe to say it might apply to most of you here on the call. Wayne asking for the balcony inspection. Once post-inspection, what happens next after the repairs required are complete? Do we need to do another inspection after that?
So you're not required to have a second inspection. You can if that's going to give you the peace of mind, but it's not something that's required. Typically, either the city's going to sign off on those repairs and tell you you're all good, or the city will ask that the structural engineer or the professional engineer or architect who created your plans for the permits sign off on them. So someone's going to have to sign off on it once those repairs are completed.
Got you. Steve asking that if the repairs are required, even non-emergency repairs, he says, I assume the lenders will not finance until the repairs are completed. Is that correct?
I wouldn't be 100% sure if you're still within your time frame.
Mhm.
Now, if you're not within your time frame, if you're maybe those repairs were due a year ago and you haven't completed the repairs, my guess would be no. If you're still within the proper time frame, I wouldn't be 100% sure.
Yeah, Annie did mention in a comment here that their inspection company was required to submit the reports to Fannie Mae and Freddie Mac. And until those priority repairs were completed, the owners have not been able to obtain refis and the potential owners cannot get mortgages. So sounds like that might be the case with Fannie Mae, Freddie Mac. Okay, and also asking, how does the state know that you complied with getting the report done?
So at this time, once again, they're only asking for failing reports. Uh, you're required to keep this in your record for 2 cycles, because they're eventually going to be asking for those, and that's why the law reads that they can fine you $100 to $500 per day for any day you were late on complying. So that's how they're trying to cover this, where they don't have the capacity to ask for all reports at this moment. But once they do start asking for those reports, your report should say that you complied, in a timely manner, or else at that time they might start assessing penalties.
Gotcha. So, Dr. Balcony does not or automatically send a copy of the report to the city.
For failing, we are required to.
Yeah,
For passing, not at this time. They're not asking for any passing reports. They're just asking that you keep those in your record.
great. A couple people asking for the cost of the inspection. I think that is going to depend, if I'm not mistaken. They might need to contact you to get that calculation.
Yeah, exactly.
Yeah,
Just contact us and we'll give you a price immediately. It's free, no commitment necessary. Uh, but yeah, just give us a call.
Okay, great. I'm going to go back to a couple questions for Edrin. So if the tenant is required to take photos during a self walkthrough upon move-in, does that fulfill the photos upon move-in requirements, or does the landlord need to be the one taking those photos?
The landlord has to be the one taking the photos because whatever the tenant has in their possession. And really, the landlord should be doing it for their own protection because, as I mentioned earlier, you're going to have to include those photographs when you're doing the security deposit itemization down the line. And if the tenant is the only one in possession of their own photographs, you're not going to have anything on the back end. And then you won't be able to deduct from the deposit. So the best rule of thumb is to take your own photographs in the pre-move-in inspection.
Hmm. Good advice. Anyway, I think we want to probably be there for that. Mary, also asking about the credit reporting. Can you auto opt in your residents for credit reporting?
No, you have to just give them an option because, especially because of the pass through on the charges, because you can charge them up to $10. And I want to make something clear. This is only a notice to give them the option to opt in. All you got to do is notify them of their right to have their positive rents reported, and that's all. If you don't hear back from them, you don't have to do it. And if they say no, you don't have to do it. But you cannot automatically opt them in. No.
Great. Wally was asking as well where you can get the form to provide the tenant to notify them about that credit reporting requirement.
Yeah, you can contact my office. Otherwise, different organizations, for instance, the Apartment Association, CAA, would have those forms online. Just make sure they're compliant with the law. Essentially, you have to let the tenants know the existence of the law. You have to have a checkbox where they can check off and say, yes, I want my positive rents reported. And you have to notify them of the charge pass through, the up to $10 for the fee associated with reporting.
Okay, great. Thanks for clarifying that as well. Let's see if we have any others here that might be separate from the balcony inspections. Let's see. Oh, yes, Haley asking about those 21 days that you mentioned
Mhm.
earlier. Does that include weekends and holidays?
It does. Yeah, it's 21 calendar days total. And
Okay.
if you miss the date, you're not allowed to deduct a penny from the security deposit. You have to send all of it back, even if there's a whole lot of damage and it's going to cost you a boatload of money to make those repairs.
Okay. Let's see. Do these changes of the AB 2801 and AB 27 pertain to 2747, sorry, pertain to affordable housing as well?
Yeah, they would equally apply to
Mhm.
everything. Yeah, the law doesn't distinguish in terms of who the tenant is or where the source of the rent payments are coming from.
Okay. Um, for the balcony inspections, I'm going to go back here for a couple of those. Does the building need to be of a certain age in order to be required to do the balcony inspection?
Yeah, so I believe it's if your building's certificate of occupancy permit was issued before 2021, that you are required to have that inspection by the deadline. If not, it's going to be 6 years after that certificate of occupancy was given.
Great. And also, does it only pertain to wood framed buildings?
Yes, there has to be some sort of wood, even if it's enclosed or exposed. As long as there's wood, you have to have that inspection done. If there's no wood at all, you're going to be all good.
Great. I'm seeing several questions about whether or not the balcony inspection law would still apply. So if you're still confused about whether or not it applies, it's always a good idea to just reach out to Dr. Balcony and they'd be able to tell you for sure. So you can see on the screen we have their email and their phone. Again, we're also going to email you their contact information as well in case you really need to figure out if it is applicable to you. So let's see here if I could find another one that we haven't answered already. There's a few duplicates. Oh, this is interesting. Chris says, I have several properties of similar size that were inspected by different companies. Some inspections were 50 pages and some were over 700 and a couple were less than 20. What requirements are there from the inspection company?
So that's going to be this slide over here, let me see. Let me see if I can go back and show that slide. So there's a couple of different requirements for that inspection report, right? You have to make sure they're identifying all exterior elevated elements. There's photos as well. Current physical condition is shown. Uh, any maintenance recommendations and expected future performance, as well as the stamp and signature. So as long as it has these items, the report should be valid. But obviously, the more detail, the better, in our opinion, right? Perhaps some of these companies purely did a visual inspection as opposed to intrusive testing. When that's the case, my recommendation is the intrusive testing is always going to be a lot better, just because like we saw in that other slide, it's going to show you, possible uh, rotting or other issues that a visual inspection wouldn't show.
Hi. Catherine was asking for the balcony inspection that requires holes in the stucco. Does Dr. Balcony repair those holes when they're done if no repairs are required?
So we're going to use a small plastic plug that we're going to patch it up with. You're more than welcome to repair that stucco yourself. We don't do that ourselves. However, the reason we don't recommend for it to be patched up is because we're going to use those same holes again in another 6 years, right? So the plugs aren't really too noticeable. We have different plugs, different colors that are going to match your stucco as close as possible. And my recommendation is just keep those in there. We haven't had any issues with those.
Okay. There still seems to be several people saying some confusion about the pet deposits not being allowed to exceed 1 month total with the regular deposit. So I would say, if you have an attorney that's telling you something different, definitely, go with whatever attorney you're working with. I don't know if you have any comments, Edrin, to that. I know there are some of these laws that can be interpreted a little differently, so
Yeah,
maybe you can
the general
expand.
look, the security deposit law, the California law, is governed by Civil Code Section 1950.5. And that sets forth what deductions you can make from a typical security deposit. Okay. Generally, that does not include a separate deposit for a pet. So, under the California state law, you're allowed to charge a separate pet uh, deposit. Now, that is further limited by local law. This is why I always discuss during my presentations that the jurisdiction where the property is located is crucial to determining what you're allowed to do and what you're not allowed to do. Different municipalities, different cities are going to permit you to do different things. And when it comes to a pet deposit, some cities curtail your ability. They allow you to charge a maximum amount. Some cities do not allow you to charge anything. Okay, so it really depends on A, the type of property you have, and B, where it's located, because we have to determine if there's a local law on the books that further restricts your ability to charge a separate pet deposit.
Okay, thank you again for clarifying that. I think we should all definitely have a good understanding of that now. Also, I know we're like over the hour mark. Are you all okay with staying a little longer to answer a few more questions?
I got to run. I got a court
Okay.
appearance in 3 minutes. Always a
Oh my
pleasure.
goodness.
The judge is gonna sever my head if I'm late on that. But always a pleasure being with you guys. Love your viewers. Greg, thanks so much for the valuable information,
Thank you
keeping
so
everyone up
much.
to speed on compliance. Alexandra, I will see you next time, hopefully soon.
Sounds good. Great.
All
Can you
right.
stay for a few more
Yeah,
balcony questions?
no problem.
Okay,
Okay.
let's do it, guys. So we're just going to be answering balcony questions. Thanks, Edrin.
You
Good
got it.
luck. Take
Thank you
care.
so much.
Appreciate it, Adrian.
All right. So I'm going to skip over anything not balcony for now. If you have any non-balcony or security deposit questions, definitely send those to Edrin. Again, I'm going to send you his contact information tomorrow in the email with the recording and the slides. Okay, so let's do a couple more deep dives here into the balcony inspections. Caitlin, for the balcony inspections, do we have to inspect all of them every 6 years or a portion every 6 years?
So as you can see in this slide, it what's required is only 15%. Assuming that you're talking about apartments, it's only going to be 15% of each type of exterior elevated element. So if you have five balconies, you're only required to have one of those inspected. Now, we always recommend the more the merrier, right? Be sure in those results. We're usually going to do a minimum of about 30% sample size. So just to be sure in those results. But yeah, only 15% is required.
Okay, good. Thank you. That's really important. Also, I did notice some people asking about the credit reporting, like what company to use and the addendum. We have one that we're partnered with called Front Lobby. I'll send you all the link in the email tomorrow as well. They do have it's free for landlords and the tenant basically pays, but landlords can also, if they want to submit like a debt, you can pay for that. So that would be like a collection versus like reporting the rent as a like a line of credit. So you can still report a debt in that format through Front Lobby. So I'll send that to you guys tomorrow in the email as well. Okay, so a couple more questions here about the balcony. Let's see. Okay. Sample size. Is that per property or our portfolio as a whole?
So that's going to be per property. So per property, the sample sizes are per property. Your portfolio as a whole, every property with exterior elevated elements, even if it has one balcony, one tiny little landing, has to have an inspection done.
Okay. Does SB 721 apply to single family homes?
Three or more units.
On it. If I have less than five rental units under LLC, is it considered mom and pop landlord? So mom and pop is a informal term, but we do consider five or more units in a building to be multifamily. That's kind of how we would define it. But there are laws that may have different definitions of like what they consider to be exempt from the law. So, with the balcony inspection, as Greg mentioned, that's like one number, but it's different for, let's say, the rent control laws in some places. So just make sure you're always checking in to make sure it applies to you with an attorney or with an expert if it's a balcony related, like Dr. Balcony. Okay. Um, what if the deck is over a garage or a storage room?
So those are always tricky. It's a case by case scenario. If it's extending beyond the garage or the storage room more than a foot, I would say yes. Definitely get that inspected. But if it's not, it may still require inspection. It just depends on it's a case by case scenario. So feel free to send us the photos at info@drbalcony.com. Send us a photo of the inside of that garage or storage area, and we'd be able to help you out with that.
Hey, great. I think you might have answered this earlier. Dabino saying that one of our balconies failed the inspection and we took permits and repaired it. Do we need to do another inspection or are we good?
Nope, you're gonna be all good. As long as you
Mhm.
receive permits and you had the sign off, you're gonna be all good.
Great. Let's see here. We are post-inspection. We received the report with some items that need immediate repair. The estimates came in at a total of over $400,000. The HOA does not have the money to make those necessary repairs. Besides a loan, what other options are there? Are there any grants or programs that can assist with those high costs due to the new law?
Wow. No, yeah, that number is really high.
Yeah.
Obviously, I don't know how big this property is, right? So it may be a 400 unit property. But my recommendation would be, see, I'm a bit confused on whether you already received permits or not. If you already received permits and then those repairs are being they're quoting it based on the permits, then I would say just receive multiple bids and make sure that you're receiving a competitive offer. If you have not received the permits, though, I would say have an engineering firm create those permits. A lot of times, the same company that you're doing the inspection with will be able to provide those permits as well. Receive those permits, and then once you have those permits, then receive bids, right? Because if you give the contractor the ability to fix these balconies any type that they want, in any way that they want, it can turn into a much bigger project than it actually has to be, right? So there's a million ways to repair any balcony that's damaged, and for example, a perk of going with an architect or an engineer such as us is that we don't have that conflict of interest when it comes to that construction. So we're going to be able to minimize that project and make it as simple as possible. Where if I'm a contractor and I'm trying to, get this project, I can say, hey, let's just tear these balconies down and start them from scratch and make it a much larger project than what's actually needed.
Yeah, okay, that's excellent. So you get like a very realistic view of what needs to be done. Also, someone had asked, Stephen had asked earlier, you mentioned some stats about those injuries related to the elevated exterior elevated elements failures. Were those stats all for EEEs? It's
Yeah, so
wow.
we included the let me see. Why
Yeah,
we
it's
included the report at the
quite
bottom
the
as well,
number.
just as our
Wow.
citation. But
Okay. Gracie was asking, does this include any interior walkways, such as hallways on a second floor?
uh walkways on the second floor, you said interior?
Yeah.
Yeah, if it's interior, no. You're going to be exempt from any inspections. It has to be on the
Yes.
exterior.
One of the E's in the EEEs is right. Okay. Question for Dr. Balcony from Nona. Can we send the photos of our concrete or metal balconies for you to identify if we are still subject of the inspection?
Yeah, sure.
Okay.
Send us those photos at info@drbalcony.com and we can definitely help you out.
Okay. And Julie asks, and if the condo HOA does not have the balconies inspected, who is liable?
So that's a case by case scenario, just depending on your agreement with your condo or HOA. I've seen different condos or HOAs where the majority are going to do an all-in-one inspection where they're going to hire us to go out there and do all balconies, all walkways, all stairways. But we have had a few condos or HOAs that just say, hey, we're only responsible for those walkways and stairways, and the individual owners, as per our agreement, uh, are responsible for their own balconies. I will recommend against this highly just because it's a lot more expensive if you hire companies individually, and then people may hire different companies, reports may
Mhm.
be different. So just for uniformity and to save money as a whole, I would always recommend um, do the entire thing all at once, but that's going to, as far as who's responsible, that's going to depend on your agreement with your HOA.
Great. That answered someone else's question as well. So that's good. Um, is there a deadline for when the work actually needs to be completed?
So the deadline is given to you depending on your inspection results. So if you have a non-emergency repair, as we spoke earlier, you're going to have 4 months to apply for any necessary permits. After the permits are issued, another 4 months to complete any necessary repairs. If you have an emergency condition, those timeframes are going to be a lot shorter. So just depends on your results.
Okay. So I think we already answered this one, and it just keeps coming up about those repairs. If they're non-emergency or minor and they don't require a permit, what is the process for reinspection after the repairs are made? Someone asked if the Dr. Balcony quote includes the reinspection. So lots of reinspection related questions is what I'm
Yeah.
seeing here.
So it doesn't include a reinspection, right? If you want us to go back out and do a second inspection, right, we can, but that's something that's completely separate. If you don't have any sort of typically if you don't need any permits or if it's just very, very minor repairs that are needed, a lot of times these exterior elevated elements are going to pass and it's just going to be under maintenance required anyway. But at least with us. But if you do have maybe repairs that aren't required, then at that point just keep records that you did fix this. Give that to the city, and they would either give you their next steps or they would tell you, hey, you're all good to go. Once again, the city's the only and people that have the authority to enforce anything, right? So as long as the city says you're good, you're all good.
Okay. Well, and if the city says you don't need any permits, then you're good.
Yeah.
That answer Anne's question there. Okay. What if the owner is responsible for the balcony repairs and not the HOA? Will multiple permits be required?
Yeah, unless you team up with your other members of the HOA and you all get one big permit, right? But that's why it's so much more expensive because if you're all applying for your own permit, if everyone's getting their own drawings and hiring their own architect or engineer to do these permits, then it's just a lot more chaotic and a lot more expensive.
Hmm. Okay. Let's see. I'll just go over a couple more. We still have like 20 plus questions, which would take us all day to probably get through. So we've answered quite a few, and I know there were quite a few like that I marked as answered, just so you guys know that well, I only marked it that way because technically like we have already answered them with other people's questions. So I'm just trying to kind of stay organized. But if you still feel like your particular question wasn't fully answered, that's why we have Dr. Balcony here. Their team is fantastic. You may even be talking to Greg. So I would say reach out to them if you don't feel like we address your question fully. We're doing the best we can with the amount of questions we have. So I'm going to just choose a couple more and then we'll call it a day. So the first one here, let's see. Da, 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 da. Let me go down a little bit. Okay. Is it correct that SB 326 is only applied for condo, but not applied for PUD like a townhome?
SB 326. So as far as I know, townhomes are going to uh typically require exterior elevated elements if it's part of an HOA, yes.
Okay, gotcha. And then if the balcony and stairs were inspected by a general contractor and repairs are needed, do those repairs have to be submitted by a licensed architect or engineer?
Sorry, can you repeat the question?
If the balcony and stairs were inspected by a general contractor and repairs are needed, do those repairs have to be submitted by a licensed architect or engineer?
So I'm guessing they're talking about the permits. Typically, the architect or engineer are going to be the only people that are able to, submit these drawings for you know, the permit to be given. But a lot of times the contractor may have a specific license or they may know someone else, they may have their own architect or engineer. Uh, Once again, it's not recommended because then you're giving them the power to choose how they conduct these repairs, but it may be possible that they have their own
Mm.
source for these permits.
Great. John asking, can you request the result of the balcony inspection report that was done on the HOA from the city of jurisdiction?
Not that I'm aware of. I
Okay.
would say if you're part of the HOA, typically they should give you a copy of that report anyway.
Okay, great. I'm going to stop here. There's still some questions left. So again, if we didn't get to your questions, I'm going to send these questions over to the Dr. Balcony team. You can also reach out to them directly with the information on the screen. They have some really awesome offers for you here. So if you do still need to have your balcony inspection, you can get a really good discount just because you were on this webinar. And you also get that deposit proof software, which is really great if you need to comply with that security deposit law as well. It really keeps things organized and compliant. So I love that Dr. Balcony is giving us more new tools to comply with all these crazy California laws. It's nice to have experts on our side that are also making it easier, especially for smaller owner and operators. I know it can be a challenge. So we're doing our best here to give you all the resources you need. And Greg, thank you so much again for taking the time to go through this. We are going to be meeting up next week again to go over a little more in depth some of the things that we went over today, but even more so on the actual, inspection process. And so I invite you to come with us again next week. I will send you an email with that information so you can join in. And then we will stay in touch with you again. The recording, the slides, the speaker contact information, all coming your way. I'll also send you the credit reporting company I mentioned if you all need a source for that. So again, thank you so much, Greg, for sticking around so long. We appreciate your expertise as always.
Of course, thank you for having me.
All right, everyone, take care. And I hope you all have a wonderful day. Bye.